This show is intended to help listeners understand the new opportunities that are now available to college and high school athletes as it relates to name, image, and likeness. The information contained in this show is only meant for educational purposes and is not meant to be legal advice or to establish an attorney-client relationship. Hello, everyone, and welcome to another episode of Court to Court with the Esquire Coach. It's been a while since we've done an episode like this. On my last episode, I had the opportunity to catch up with Dr. William Hill, the creator and visionary of the new social networking ecosystem, Athlete Forever. Athlete Forever is a social networking platform for current, future, and present college athletes, or really any athlete, and those who work within the sports industry. It creates a platform for those who are interested to sign up, create an account, and be able to connect with others who have similar interests. So if you would like to sign up for Athlete Forever, you can find a link to it in the show notes here. And if you would like to check out the episode, please do so. As always, there's a lot going on in the college athletic space, and we're going to get into quite a bit of it today. In this episode, we're going to talk about the settlement that the NCAA just reached to allow athletes to be able to use NIL while recruiting. And we're going to talk about the upcoming House settlement and the fairness hearing that is coming up. We're going to talk about colleges and conference plans to engage in revenue sharing if the settlement is approved. And we're going to talk about concerns over NIL revenue sharing contracts and much more. So let's get into it. The NCAA has reached a settlement in the case regarding college athletes being able to negotiate their NIL while being recruited and during transfer. Last year, the NCAA was sued by attorney generals in Virginia and Tennessee. They were later joined by Florida, Washington, D.C., and New York. The AGs alleged that the NCAA's rules prohibiting college athletes from being able to negotiate their NIL during recruitment and during transfer caused irreparable harm while depriving the athletes of their most marketable opportunity to negotiate their NIL, which is the time when they are initially being recruited and when they're considering transferring to another school. The judge agreed and granted a temporary restraining order at the time, which stopped the NCAA from enforcing its rules prohibiting athletes from using NIL during recruitment. But the NCAA has now reached a settlement in that case, and now college athletes will be able to negotiate their NIL while they're being recruited and when they are considering transferring to another school. So what do you guys think about this? Drop a comment in the comment section below. We are now less than a month away from the highly anticipated House Settlement Fairness hearing that is scheduled for April 7th. During that hearing, Judge Claudia Wilkin will make a decision on whether to give the House settlement final approval or not. There are reasons to question whether the settlement will be granted final approval, as many current, former, and future college athletes and other professionals in the sports industry have filed objections to the settlement. Future and current college athletes have filed objections, noting that they have issues with the impending roster limits that will come a part of the settlement. Many schools have begun to prepare for that by downsizing their teams, which has resulted in several players losing their spot currently on the team, or several future college players who are graduating high school this year and will be entering college in the fall having their offers rescinded due to the university beginning to prepare for the impending roster limits. For example, one objector who is a current high school student objected due to having his offer to play college football rescinded as part of the team's preparation for the impending roster limit changes. Some college athletes filed objections, noticing their experience with being a preferred walk-on as opposed to a college athlete who may have received a full grant and aid. One objector noted that the exclusion of preferred walk-ons and what is referred to as the settlement football and men's basketball class only includes those athletes who received a full grant and aid. And the objector noted that even though he was a preferred walk-on, his contributions to the team are the same as any athlete who may have received a full grant and aid. He noted that his NIL was used in the same way as other athletes who received a full grant and aid, and feels that because of that he should be able to be a part of that damages class. Several athletes also objected on the basis of Title IX. And you had sports industry professionals, such as attorneys and other industry professionals, taking issue with the $20.5 million revenue sharing cap that has just kind of been placed on the amount that schools will be allowed to share with their athletes. And they claim that this is just still an antitrust issue. It's just that now, instead of the cap being at $0, it'll now be at $20.5 million. So there were a lot of valid points raised through the objection process that the court, may consider as they determine whether or not the settlement should be approved. All of these issues, in my view, point to the main problem with this attempt to address some of the issues in college sports. And that problem is the lack of a strong voice for the college athletes. College athletes do not have a union, although there are some organizations that have worked to give college athletes some sense of a voice in like a union-like entity, such as athletes.org or the College Football Players Association. However, college athletes still lack a union to represent their interests in the same way that professional sports have unions, such as the NBA has the NBAPA, the NFL has the NFLPA, the WNBA has the WNBAPA, all players associations that represent the interests of the athletes in those professional sports. So this is important because the way that professional sports are able to cap the salaries of their players and do other things is that they collectively bargain for those issues, and they make an agreement called the collective bargaining agreement to abide by the rules that are negotiated between the league, such as the NFL, along with the Players Association, the NFLPA, just to give an example. And here, college athletes do not have that. So, I think anytime that you continue to place limits on what college athletes can do without adequately making sure that their voice is heard and represented, and in a sense collectively bargaining with them or some form of quasi-collective bargaining with them, we're going to continue to have issues. Again, the settlement hearing is scheduled for April 7th, and Judge Wilkin has set the rules for the hearing, and she announced that 14 objectors will be allowed to testify during the hearing. Among them are LSU star gymnast Olivia Dunn and Michelle Roberts, the former NBA PA executive director. In the order, Judge Wilkin made clear that she cannot order changes to the agreement, as some athletes suggested that athletes be grandfathered in so that they're not subject to the outcome of the roster limit changes. But Judge Wilkin made clear that she is not going to make changes to the settlement agreement and will ultimately be considering whether the settlement meets the requirement of being fair, adequate, and reasonable. So we will all be holding on to our hat until April 7th to see how the hearing goes and waiting for the judge's ultimate decision. As we just discussed, all of college sports is waiting for the fairness hearing on the House settlement. However, colleges and conferences have already begun to prepare for the impending changes if the settlement is approved. As I already stated, colleges will be able to share up to $20.5 million with their athletes under the House settlement if it is approved. Earlier this week, the American Athletic Conference made news as the first conference to set a revenue sharing minimum for the colleges that are a part of their conference. The American Athletic Conference will require its schools to share at least $10 million of athletic revenue with their athletes over the next 3 years. So meeting this minimum amount, they will be paying out approximately $3.33 million or more a year to their athletes. So what do you guys think about this? The fact that a conference has set a minimum payment for their schools to engage in revenue sharing with their athletes. Do you think that we'll see more of this? Do you think that we should see more of this? Let me know in the comments below. While we wait for the outcome of the House Settlement Fairness hearing, let's take a second to address something that the House Settlement does not address, and that is the issue of whether college athletes should be deemed employees. As I said, the House Settlement has no bearing on this issue. However, there is still ongoing litigation regarding employment of college athletes, such as Johnson versus NCAA. Many college sports administrators are against college athletes being deemed employees, and they have several reasons for that stance. However, there appears to be no problem, at least amongst some, with imposing employment-like concepts on college athletes, as can be seen through provisions in revenue sharing contracts that have been developed in preparation for the House settlement if it is approved. ESPN recently reported on these contracts, pointing out how many of them are riddled with employment and pay-for-play like concepts. Some of the contracts are structured so that the universities can, in a way, regain control over the athletes by restricting their ability to transfer, by requiring them to pay buyouts if they transfer. And some of the agreements state that they're not pay-for-play agreements, but they also state that the school may increase or decrease their payment based on the athlete's performance. So controlling an athlete's ability to transfer and leaking the athlete's revenue share amount to their performance definitely seem to have employment-like concepts within them. And again, the athletes are left with no true voice in the drafting of these contracts as they're being drafted by the conferences and universities, really with no real input or interest represented of the athlete. While I'm not suggesting a true employment model for college athletes, I am suggesting that college athletes need to have a better seat at the table and that they need to have a stronger voice to represent their interests. As I stated earlier, in professional sports, those players have that through their different players associations who collectively bargain on behalf of the athletes in the respective leagues. So college sports must figure out a way to provide college athletes with a stronger voice to advocate on their behalf in matters such as this. And college athletes will certainly need representation and industry professionals who can teach them what to look out for in these type of contracts and other contracts as they pursue other NIL opportunities. It is for this reason that I am launching a course designed to assist industry professionals with understanding the current state of college sports and how to assist college athletes. The course is entitled Mastering NIL, A Professional's Guide to the NIL Era of College Athletics. The course will be in 3 parts. Part 1 is understanding NIL and the current state of college athletics. Part 2 is how to help athletes build NIL marketable brands. And Part 3 is the anatomy of an NIL contract, where we'll break down how to assess the various contracts that college athletes may receive. If you're interested, the link to sign up for more information about the course is in the show notes. On March 4th, the United States House Committee on Energy and Commerce held another hearing on college athletics and NIL. The hearing was entitled Moving the Goalposts, How NIL is Reshaping College Athletics. This is the 12th congressional hearing on NIL. However, this one is the first one under the current presidential administration and with the Republicans controlling both the Senate and House of Representatives. So what does this mean? It's not clear yet what this could mean for the future of a national law regarding NIL in college sports. However, the Republicans tend to lean more towards giving the NCAA an antitrust exemption that it seeks to prevent some of the litigation that the NCAA still currently faces. And the Democrats seem to lean more towards athletes having a stronger voice, whether through collective bargaining or some variant thereof. There was not a lot of clarity gained during the hearing as to what it will really take to get federal legislation. The only thing that was clear was the possibility of more congressional hearings before the fairness hearing in the House settlement, which again is scheduled for April 7th. More state NIL-related legislation. In 2019, when California became the first state to enact a law seeking to allow college athletes to profit from their name, image, and likeness, other states quickly followed suit. That is because other states wanted college athletes in their state to have the same advantages and opportunities as college athletes in other states? Well, here we go again. We have some states who have begun enacting legislation to exempt college athletes from paying income tax on their NIL earnings. The state of Georgia, who has a state income tax rate of 5.39%, introduced this type of legislation along with Alabama and Illinois. The Alabama bill would exempt college athletes' NIL earnings from being taxed by the state. The Illinois bill would amend the state tax code as currently written and would go into effect in 2027. Proponents of this type of legislation view it as an opportunity to level the playing field, while other states like Florida, who do currently have no state income tax. So what do you guys think? Do you think that this is something that should catch on and should be allowed for college athletes? Let me know in the comments. While we are waiting to see if colleges will be allowed to engage in revenue sharing under the House settlement, some states have already taken matters into their own hands and will allow colleges in their state to do so regardless of the outcome of the settlement. So the Colorado state legislature passed a law to allow colleges to directly compensate their athletes. Colleges and universities in Colorado will be allowed to compensate their athletes, and the names of the athletes and the value of their contracts will be exempt from the Colorado Open Records Act. Colorado joins Virginia, who was believed to be the first state to pass such a law, as last April, Virginia passed a law allowing Virginia colleges and universities to directly pay their athletes for their NIL. So whether the House settlement is approved or not, states are taking action to ensure that schools in their state will be able to directly compensate their athletes at their respective schools. What do you guys think? Do you think that this will catch on as well and other states will do so even if the House settlement is not approved? Let me know in the comments. College football players will be paid more for EA Sports College Football 26. EA Sports recently announced that college football players who participate in the video game EA Sports College Football 26 will get an increase in pay for inclusion in the game this time around. Per The Athletic, college football players who opt into the game will now receive a payment of $1,500 and a deluxe edition copy of the game. Last year, EA Sports College Football 25 was released in July, and players who opted to be included in the game received a $600 payment along with a free copy of the video game. While this provided financial rewards to the athletes that had not been previously available, I was very critical of this deal, as I believe that the players who opted in should have had an opportunity to receive royalties and more upfront cash. The universities had an opportunity to receive a bigger piece of the pie, as EA Sports set aside 10% of the sales revenue for a licensing pool for the participating colleges and universities. However, the athletes were capped to a $600 payment and a copy of the video game. It is important to note that cover athletes did receive a separate deal for being featured on the cover. But this time around, participating college athletes will receive $1,500 and a deluxe copy of the game, and some athletes will still have the opportunity to receive additional compensation for serving as brand ambassadors and for being a cover athlete. The return of the college football game last summer was a huge success. It was one of the best-selling video games ever, and EA Sports is now looking forward to the release of EA Sports College Football 26. Last month, a company named Pathways Sports and Entertainment, that is led by Casey Schwab, stated that the company was focused on monetizing college athletes' NIL rights, and they had entered a licensing agreement with over 450 college football players at schools such as Georgia, Illinois, and Alabama, where they were working to get the college football players a $1,500 payment for being included in the EA Sports College Football 26, and was also working to get them royalties for being included in the game. However, EA Sports says that the Pathway Sports deal had nothing to do or had no impact on their decision to increase the payment for participating college football players. But the athletes are still not receiving royalty payments. So perhaps that is something that Pathway Sports and Entertainment can find a way to negotiate for the players, an opportunity for them to receive royalty payments. We will just have to wait and see. But one thing that is for certain is that the college football video game is a success and a major opportunity for the participating athletes. Well, this concludes this episode of Court to Court with the Esquire Coach. I hope you all enjoy. If you have any comments, please feel free to leave them there. Please follow me on all the socials that you see running at the end of the screen. And if you have any interest in any other things that we discussed here today, you can find the links to them in the show notes. Thank you, and see you next time.